This is Meet the Past, the news program that speaks with influential figures of the past to confront the challenges of the present. This week, moderator Kenya Williams hosts a special edition to commemorate the 800th anniversary of the Magna Carta. An enormously influential document, Magna Carta changed the course of history in England and served as an inspiration for the Declaration of Independence and the United States Constitution. This week's guests include King John, the English monarch who placed his seal on this historic document, and Robert Fitzwalter, one of the barons who stood against King John. Also joining the round table will be parliamentarian Sir Edward Coke, founding father John Adams, suffragette Susan B. Anthony, and the great emancipator Abraham Lincoln. We'll also seek the insights of Richard Nixon, the only sitting president to resign from office. And now, on location in Redondo Beach, California, moderator Kenya Williams.
Thank you, Jeff. To commemorate the 800th anniversary of Magna Carta, one of the most important documents in this nation's history, our program this evening will focus on the events leading up to the drafting of Magna Carta in England and the role Magna Carta has played in subsequent years, both in England and across the pond in the United States of America. We'll talk to some of the key players in the drafting and implementation of Magna Carta, as well as learn about the modern-day interpretation of its importance. Before we turn to our key players, we have a special guest, Magna Carta of 1215.
Here I am in the grassy field of Runnymede, where, in 1957, the American Bar Association set up a memorial to me to commemorate the fundamental concepts of liberty that had their beginnings with me and were transplanted to the American colonies, where they were accepted, refined, and embedded in the instruments of government as well as the thinking of the American people. In 1215, King John placed a seal on me to settle an uprising by the barons against the king, resulting from what were perceived by the barons as tyrannical actions imposing on their inherent rights as English citizens. Notwithstanding that I was repudiated by King John and Pope Innocent III within 3 months, over the following 200 years I was reinstated and republished in various forms. Ultimately, most of my chapters were incorporated into statutes by Parliament. Of the 3 remaining chapters, the most significant is Chapter 39, or Chapter 29 of the 1225 Charter, which reads, quote, "No free man is to be arrested, or imprisoned, or disseized, or outlawed, or exiled, or in any other way ruined, nor will we go against him, or send against him, except by the lawful judgment of his peers or by the law of the land." End quote. This has been interpreted to be the promise of the rule of law or due process over the years, so that no person is above the law, including the king. Since my original issue, I have been reinterpreted by legal scholars in England, specifically Lord Coke and Blackstone, to where a myth has built up attributing to me more than what was originally written. Those myths were transported across the pond to the colonies, which relied on me in support of the decision to declare independence 560 years after King John originally placed his seal on me. As with my original provisions, your Declaration of Independence listed a number of grievances against the king, declaring him to be a tyrant. Included within my original chapters were protections for the English Church, petitioning the king, freedom from forced quarter of troops and unreasonable searches, due process and fair trial protections, and freedom from excessive fines. These protections can be found in the 1st, 3rd, 4th, 5th, 6th, and 8th Amendments to your Constitution. The United States Supreme Court has cited me in more than 170 cases, not as his authority, but as historical background. As noted by Stephen J. Wermiel in Chapter 5, titled Magna Carta in Supreme Court Jurisprudence, contained within his book Magna Carta and the Rule of Law, at page 111, quote, "There is a common theme that spans 2 centuries. The role of Magna Carta is largely symbolic. For Supreme Court justices and the lawyers who argue before them, Magna Carta is venerable historical evidence invoked to establish the pedigree of a claim that a particular right exists or determine what that right means. As justices have made clear in speeches and decisions, however, Magna Carta is not and cannot be positive law in the Supreme Court, since it far predates the writing of the United States Constitution, which created the Supreme Court. I am important to you as a touchstone in aid of establishing, enforcing, and interpreting the rights guaranteed by the United States Constitution and the constitutions of the various states. That is why you will be celebrating my 800th anniversary in June of 2015.
Magna Carta is the seminal document from which the liberties of all subjects of the Crown flow. That document, through 2 iterations, was largely ignored for centuries after the parties agreed to the terms of Magna Carta. Beginning in the 17th century, however, largely through the influence of the writings of Lord Edward Coke, one of the most respected jurists of his time, Magna Carta influenced in an extraordinary manner the rights and liberties of individuals and the limitations of power over individual citizens. Lord Coke, although you may believe that your place in history would be based on the decision you wrote in what was later known as the rule in Shelley's case, did you realize that your statements and rulings regarding Magna Carta would eclipse your other decisions?
No. Truthfully, as a result of my statements regarding royalty and Magna Carta, I was transferred from Chief Justice of the Court of Common Pleas to the King's Bench, where it was felt I could do less damage to the Crown. Thereafter, King James had me accused of treason, which earned me 7 months in the Tower of London.
Lord Coke, you interpreted Magna Carta to apply not only to the protection of nobles, but to all subjects of the Crown equally. If Magna Carta is read only using the words used by its authors, and if we look to the literal words of either Magna Carta 1215 or 1225, didn't the terms apply primarily to the barons and only incidentally to all free men, which at that time included only knights and some property owners? In other words, how could you possibly apply Magna Carta to all subjects of the Crown?
I believe that English common law, in order to be or to become the common law throughout the British Empire, needed to include all subjects of the Crown.
The charter at Runnymede was not intended to reach popular liberty for all. Why is it important?
At the time it was written, the Charter of Runnymede was a profound act for which its proponents risked their lives, their fortunes, and their eternal souls through threat of excommunication. This one document led to the rule of constitutional law in England and throughout the British Empire, even after some colonies, such as yours, of the empire rejected the authority of the Crown over all of its subjects. But even those colonies recognized the benefits of the rule of law.
Lord Coke, can you point to the specific words in Magna Carta that support your position that Magna Carta provides for a speedy trial, free speech, or the rights of judges to strike down laws of the legislature? Since you can't, will you concede that you are simply one of the precursors to the liberals who interpret legislation to their own ends, regardless of the explicit words in the document?
You misunderstand the use that the lawyer in the common law system makes of history. The lawyer is not depicting medieval law as it was used in the Middle Ages and then applying that law using medieval interpretations to modern society. The lawyer in the common law system is helping old legal principles evolve. The process by which old legal principles and phrases are charged with new content is an evolution of the true intent and meaning of the law. In your country, did not your Supreme Court find that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance? Are there any words in your Constitution that mention a right to privacy? You know there are no such words. Are you therefore willing to concede that my reasoning, that only by an evolution of the intent and meaning of old written law can legal principles evolve to suit modern facts?
Thank you for your take on this, Lord Cook. King John, welcome to our program.
Thank you.
We are quite intrigued by your lineage and legacy as a leader in England and your role in making Magna Carta the law of the land. Where did you get your instructions on how to rule as king?
From God, of course.
Are you saying that you believe you were not bound by any man-made rules as king?
Certainly not.
So we want to make sure our understanding is correct. You believe you did not need to consult with anyone else in the kingdom before making decisions, even decisions that would affect a multitude of people.
That's correct. I sometimes did consult with the members of my court who were under my influence, but I didn't have to do that.
Okay. Thank you for that clarification. So you were excommunicated by the Pope in 1209. As a result, were you deprived of the ability to make decisions as king?
Unfortunately, yes. I was forced to allow Pope Innocent III to run the kingdom in my absence. But I knew this would cause such chaos and disorder that the Pope would have no choice but to lift my excommunication. I was correct. It worked. The Pope allowed me to resume ruling my kingdom once again.
Wow, that's very intriguing. Is it true that before you were king, you attempted to seize the crown from your brother, Richard the Lion-Hearted, while he was away on a crusade?
After all, that was the best decision for the good of the kingdom. Richard was never there. He had great demands for money, first to finance the crusades, and later for his ransom. I needed to be king in order to deal with these things, and that's what God told me.
But had you not sworn under an oath of allegiance to Richard the Lion-Hearted as your king?
Yes, I had. But then when he came back to England as a hero, God told me that he should be the king again, so I backed off.
So what changed your mind?
Well, God instructed me that Richard was the rightful king, having returned from the Crusades, and so I allowed him to become the rightful king again.
Okay, I understand. Some considered you an able administrator. Would you agree?
Of course I was an able administrator. That is until a civil war broke out due to the acts of traitorous barons led by Baron Fitzwalter over here. The barons were upset at my ability to maximize collection of feudal duties and taxes because I was such a great administrator. I needed money to maintain my court and style. I also needed to defend and later regain England's possessions in France.
And tell us, how did the Civil War end?
Kenny, I'm glad you asked. In 1215 at Runnymede, the traitorous barons persuaded me, under duress, to sign a document guaranteeing them and others an abundance of rights. Because of the circumstances of my signing, 3 months later I rescinded the document, as was my sole right to do as king.
Thank you, King John. I have one final question for you. Were you ever able to reassert your authority?
Mostly I did, except against some of the traitorous barons who were situated along the Scottish border and in Ireland. Unfortunately, in 1216, I fell ill with dysentery, and the peach that was supposed to cure me didn't do its job.
Thank you, King John. We certainly appreciate hearing your point of view. Our next guest is someone you know quite well, Baron Fitzwalter, who is remembered as a champion of English liberty, leader of the opposition against King John. He is here to provide some background for the events leading up to the signing of Magna Carta. Baron Fitzwalter, welcome to our program.
Thank you.
We're just going to get right down to it. What caused the revolt that led to the signing of Magna Carta?
Well, King, for years, the barons or large landowners who served under King Henry I and King Henry II took the lead in providing money and men to defend English territory, including what is now northern France. Traditionally, the king always consulted the barons before raising taxes, as it was our job to collect the taxes. And the king always consulted with us before demanding more men for military services, as we had to provide the men.
That's interesting. And what went wrong during the tenure of King John?
Since King John took the helm, our military campaigns have not been successful, and there have been constant demands for more money. The land in northern France was lost. And most recently, King John introduced higher taxes without consulting with us first. Then I was implicated in the baronial conspiracy of 1212 and was forced to flee to France to escape trial. I was unable to return until special amnesty was granted after King John's reconciliation with Pope Innocent III.
I see. And what problems was King John having with the Roman Catholic Church?
The Pope, annoyed by King John's behavior, banned all church services in England in 1207. The barons and all Catholics in England feared hell, based on an inability to attend church. King John was excommunicated from the church in 1209, meaning he could never get to heaven. In 1214, John accepted the power of the church and reconciled with the Pope. Thereafter, I was able to return to England.
So, is it safe to say that by 1214, many of King John's problems were resolved?
Actually, 1214 was another disastrous year for King John. We suffered another military defeat, and we were unable to get back the lost territory in northern France. King John was demanding more money, but we were unwilling to listen. We rebelled against his power and captured London. By the spring of 1215, he was willing to discuss sharing power. Instead of seeking to replace the monarchy, we based our rebellion around King John's oppressive government. After tense negotiations, what is now the Magna Carta was the result.
Thank you, Baron Fitzwalter. Now that we've had a chance to speak with Lord Cook, King John, and Baron Fitzwalter, I have a few more questions. Lord Cook, what do you think about King John's way of ruling? Would you have made the same decisions he made back in his time?
Although I was not present when the Great Charter was signed, I believe that the role of a judge is to interpret the written words of the statute and apply that law to the matter before the court, which may be a more modern context than the authors of the law could have ever foreseen.
What does he know, Kenyon? He wasn't even there.
I was there with you, and you pushed the barons too far. And the king not being above the law has become an important part of our uncodified constitution in England.
Well, your argument's entirely circuitous. You're basing it on a document, the Magna Carta, which is the rule of law, as you say, which I was forced to sign under duress, which I later rescinded. So how can you say it has anything to do to support anything now?
But you're basing your absolute authority on nothing more than a birthright. That way of thinking is in the past, like you, King John.
Okay, thank you, gentlemen. Now that we've heard from Lord Cook, King John, and Baron Fitzwalter, we'll have a short commercial break before we begin our next segment. Welcome back to our program. Before the break, we spoke with Lord Cook, King John, and Baron Fitzwalter. Now, let's fast forward about a half century and speak with President John Adams. Welcome to our show, President Adams.
Thank you.
First of all, we'd like to know what was going through your mind and the minds of the other founding fathers when you signed the Declaration of Independence. Did Magna Carta play a role?
Absolutely. Magna Carta was very important. In fact, we relied upon it for our notions concerning the rule of law.
President Adams, in many ways, you were the voice of the American Revolution. Yet, as a trial attorney, you represented the British soldiers who killed 5 civilians in the Boston Massacre. How can you justify that?
Through the fundamentals of the Magna Carta, as I understand them. If I may quote myself, it is more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world that they cannot all go unpunished.
President Adams, on the other hand, how can you, of all people, justify signing into law the Alien and Sedition Acts?
You know, I'm glad you're asking me that question. I've been waiting to respond to that question for many, many years.
Okay.
First of all, those laws were not my idea, naturally. They were advocated by the Federalists in Congress in response to the Democratic Republicans, some of whom were refusing to follow federal laws, refusing to enforce federal laws. And by the way, there were only 10 convictions in the Sedition Act. It was really trifle.
Still, the Sedition Act appears to be a clear violation of the First Amendment. Doesn't that mean you are just as guilty as President Nixon?
Hardly. There it is. We were a young nation trying to survive, and the Democratic Republicans wanting to pull us apart, hoping that nasty French Revolution would be important to the states.
President Adams, how can you justify so few people voting in early America in a democracy?
Democracy? We were never meant to be a democracy. We are a republic. Remember, democracy never lasts long. It soon wastes, exhausts, and murders itself. There has never been a democracy that did not commit suicide. Further, Ms. Williams, I should not say a word to you about politics because you are a woman.
Hold that thought, President Adams. I'm sure one of our other guests on the panel will have something to say to you about that. Moving on, if you think restricting anti-federalist speech was acceptable in the 1790s, then you must have no problem with President Lincoln's suspension of habeas corpus during the Civil War.
Wrong again, young lady. First, in the 1790s, the Democratic Republicans, or Jeffersonians if you must, were not seceding from the Union, but trying to overthrow my government. The southern states of the 1860s started their own country, just like we did in 1776. And you know what? There's nothing in the Constitution that says they can't. Mr. Lincoln should have let them go. And I may say, as a man who never owned a slave, good riddance.
Thank you, President Adams. With that said, let's introduce our next guest, President Abraham Lincoln. Welcome to our program, President Lincoln.
Thank you.
Did you violate the letter or spirit of Magna Carta during your controversial presidency?
Not at all. I did not violate the letter of the Magna Carta because it is not the law of the United States. And as to the spirit of the Magna Carta, my administration and my actions as president were wholly consistent. I think it's important to remember that Magna Carta is revered and celebrated for the fundamental principles that were expressed and implied in that document and that inspired our country's governing documents and institutions. And it's those institutions that my administration saved from the traitors who tried to destroy the Union.
But Mr. President, the record shows that you repeatedly arrested your enemies, even though they had not violated a defined criminal statute. You suspended habeas corpus and prevented the judiciary, a co-equal branch of government, from lawfully discharging those prisoners. What do you say to your critics who accuse you of violating the Constitution by suspending the writ of habeas corpus?
Well, first of all, the suspension clause of the Constitution provides constitutional authority to suspend habeas corpus to protect the public safety in times of rebellion. But more importantly, Ms. Williams, wars are not fought in a courtroom. And I think it's important to note that the states who withdrew from the Union and the armies that they controlled attacked federal troops and converted federal property. And as traitors, they cannot seek the protections of the very Constitution which they spurned by their acts of rebellion.
Mr. President, the suspension clause is located in Article 1, Section 9 of the Constitution. Article 1 establishes the legislative branch of the federal government, and Section 9 places limits on Congress's powers. Why do you disagree with so many others in finding the suspension clause to be a source of presidential power rather than solely a legislative power?
Well, first of all, let me clarify my position. My power as president does not derive solely or necessarily from the suspension clause. My presidential war powers, as set forth in Article 2, Section 2, provide constitutional power to suspend habeas corpus independent of the suspension clause.
But the suspension clause does not expressly say the president can suspend the writ, correct?
That is correct, but it also doesn't say whether Congress can exercise that. If you actually read the text, it's written in the passive voice and is silent on the issue. What is clear from the suspension clause is that it was meant to apply in a dangerous emergency situation. And I think the only reasonable interpretation is that the framers could not have intended that the suspension clause would only apply when Congress has time to get together and grant the president authority to suspend habeas corpus. Under the circumstances of the Civil War and the existential threat that that posed to this country, I think the only reasonable interpretation is the commander of the Army and Navy who can suspend habeas corpus. So my actions were consistent with a reasonable interpretation of the suspension clause.
But Mr. President, you state that your presidential war powers independently embrace the power to suspend habeas corpus. But like the suspension clause, Article 2, Section 2 is silent as to your powers to suspend habeas corpus. How do you infer from the Commander-in-Chief clause the power, in effect, to deprive anyone of his or her rights under the Bill of Rights by simply suspending habeas corpus?
Well, thank you for your question. Ms. Williams, when any president, including myself, assumes the office of the presidency, the Constitution requires that president take an oath to preserve, protect, and defend the Constitution. That is not an independent source of constitutional power, but the oath recognizes that the president's broad executive powers include a preserve, protect, and defend power. And the reasoning for that is compelling, because the framers would not have created a duty without conferring the power to satisfy that duty. And that power is sufficiently broad to include the authority to suspend habeas corpus in times of war, which was what I faced, and clearly under the limited circumstances of the suspension clause.
Okay, well, thank you, President Lincoln. Now I must now speak with our next guest, famous suffragette Susan B. Anthony. It's wonderful having you here this evening, Ms. Anthony. How does Magna Carta factor into the movement for women's rights? Is it important?
Thank you, Ms. Williams, and thank you for having me here. Absolutely. The Magna Carta was extremely important to the emancipation of women. It is the basis for human rights in this country, and it included rights for women. So in my mind, that great charter stands for the fact that our country has a historical commitment to political equality between the sexes.
Ms. Anthony, you were arrested in 1872 because you and other women decided to go ahead and vote illegally in the presidential election. Tell us about that.
Well, I had taken the position and argued early and often that the recently adopted 14th Amendment gave women the constitutional right to vote in federal elections. The amendment said that all persons born and naturalized in the United States are citizens of the United States, and as citizens were entitled to the privileges of citizens. Based on my way of thinking, those privileges certainly included the right to vote. Furthermore, the New York Constitution contained no sex qualification for voting privileges. So I and my sisters were able to convince the young elections clerks to let us vote. And that's what we did. Weeks later, I was arrested in my home for illegally voting. After being indicted by a grand jury of 20 men, not a jury of my peers, I was charged with knowingly, wrongfully, and unlawfully voting. My main defense was that I did not knowingly cast an illegal vote. Even if the 14th Amendment did not make my vote legal, I acted in good faith on my beliefs. But in the end, Judge Hunt directed the jury to find me guilty. By that time, the suffrage movement had a lot of support, and I truly believe that if the jury had been allowed to discuss the issue, I would not have been convicted.
Ms. Anthony, you were quoted as saying failure is impossible. Yet women did not achieve the right to vote until 14 years after your death with the adoption of the 19th Amendment. How could you be so sure that would happen?
Well, Ms. Williams, you have to understand that during my lifetime, things for women were really, really bad. We were taxed without representation. We were governed without consent. We had no right to a jury of our peers. The women of this nation in 1876 had just as much cause for discontent, rebellion, and revolution as the men of 1776. And we were not going to continue in that condition without rebellion. It just wasn't going to happen. At 86 years old, when I said that, when I looked around at all the people that were supporting our cause and all the progress we had made, I was sure we would not lose the fight. I didn't think it would take 14 years after that to have the amendment passed, but we got there.
Ms. Anthony, thank you very much for your point of view. I would now like to introduce my final guest, President Richard M. Nixon. Last, but certainly not least, President Nixon, welcome to our program.
Thank you.
I'm sure you have enjoyed listening to our other guests, and now you're in the hot seat. I'm going to ask you a few questions and then allow our guests to sort of interact with each other a little bit more. President Nixon, on what grounds did you oppose the subpoenas that were issued by the Senate Investigatory Committee and Justice Department in what became known as Watergate?
Ms. Williams, it would be inconsistent with the public interest to require the revelation of confidential conversations between a president and his close advisors. To ensure complete candor, objectivity, and open and thoughtful communications, the president should be secure in knowing that his communications with his advisors will not be subject to later public dissemination and scrutiny.
Did you also oppose the involvement of the federal courts in the dispute over the subpoenas?
Yes, the separation of powers doctrine should have precluded the judicial review of a president's claim of privilege. The federal court should have declined to involve itself in what amounted to an inter-branch dispute between the president and the Justice Department concerning the subpoenas that it issued. The same is true of the dispute that arose between the executive and legislative branches concerning the Senate subpoenas.
Doesn't your argument essentially boil down to the notion that the executive should be immune from the judicial process in general?
I would disagree. As the person who the voters have elected to lead the country, the president needs the latitude to perform his duties without the threat of politically motivated judicial proceedings that would have a chilling effect on his ability to communicate with his advisors about sensitive issues such as national security and foreign relations.
And how does the public's right to information about its government weigh into the equation?
The public's desire for information about government affairs needs to be balanced against the compelling interest in ensuring that the president competently and effectively performs his job by having open and candid communications with his close advisors and ensuring the protection of sensitive information that could threaten national security and American interests.
Mr. President, if you were so confident in your position that the tapes were protected by executive privilege, why did you resign rather than fully comply with the subpoenas?
Well, I felt it was best to preserve the integrity of the office of the presidency and avert a further constitutional crisis by resigning, particularly since it became clear there was insufficient support in Congress that I needed to effectively perform my duties as president.
Thank you, President Nixon. I'm sure a few of our other guests have other questions or comments for you, and you may have some for them as well. So let's get to it. I'll open the floor. You know what they say, ladies first. Ms. Anthony, do you have any questions or comments for President Nixon?
Thank you, Ms. Williams. I just want to say that I very much appreciate the work that President Nixon did to enforce the Civil Rights Act and the fact that you pushed hard to ban sex discrimination in employment and education under Title VII of that act. I very much appreciated that.
Thank you, Ms. Anthony, for your support.
Well, I would like to speak to Mr. Nixon briefly.
Go ahead, President Adams.
Mr. Nixon, you were so petty. You had an enemies list where you would harass entertainers such as John Lennon, who wrote a song called Revolution, which was anti-revolution. I had to deal with a real revolution next day. What you did to my Constitution is just disgraceful. You ignored checks and balances.
Untrue. If the president does it, it's not illegal. Besides, I was a popularly elected president twice. 3 times really, if you count 1960 when Lincoln and Dick Daley stole my election. Furthermore, unlike your day when only white men with property could vote in most states, I had women, blacks, and even Jews voting for me. I specifically remember Jews for Nixon. King John and I were like kindred spirits in that we both seemed to have felt that the ends justified the means and that we were not bound by rules. Right, King John?
Well, I never felt that the ends justify the means. I think you said it better a minute ago when you said that the president can do no wrong. The king can do no wrong as well. I spoke to God. I got guidance on what I understood to be best from God, and I implemented it. That's not the same thing as the ends justify the means. I seem to recall that towards the end of your presidency, President Nixon, you and your Secretary of State, Henry Kissinger, knelt down and asked God for guidance right before you resigned.
I say, the presidents you liberals love so much, Lincoln and Roosevelt, committed far worse acts than I did. The beloved Abraham Lincoln gave military commanders the power to suspend habeas corpus, but perhaps you gave Lincoln a pass because the Supreme Court never heard his case. And the beloved Franklin Roosevelt suspended habeas corpus, and 6 of the 9 Supreme Court justices agreed that regardless of their United States citizenship, Japanese citizens who were free men, as that term was understood, even in 1225, could have their property taken without due process, and that they themselves could be imprisoned or put in internment camps.
Lord Cook, I believe you may have a comment or two.
Thank you. I wrote, and therefore every subject of this realm, free or bond, man or woman, young or old, outlawed, excommunicated, or any other, without exception, may take his remedy by the course of law and have justice speedily and without delay. Your Supreme Court supported me and wrote, to Lord Cook, prolonged detention without trial would have been contrary to the law and the custom of England. Your court wrote that I believe that delay in trial by itself was by itself an improper denial of justice.
Okay, to wrap up our program, I'd like to ask our guests one final question. How would you sum up the importance of Magna Carta?
If the president does it, it's not illegal.
The Magna Carta stands for this country's historical commitment to political equality between the sexes.
An inspiring document and an enduring legacy.
Remarkable, particularly in its time, the Middle Ages, hundreds of years ahead of its time.
When incompetent leaders like King John come along, it's especially important that kings are not above the law.
It was a document of no consequence, extracted under duress, which was rescinded almost immediately.
If judges and lawyers are not willing to stand up to those who would run roughshod over the rights of citizens, then the liberty of all is at risk, and that is no less true today than it was 800 years ago. Mrs. Williams.
Thank you all my guests. That concludes our program. Thank you all for listening.